Hey, I'm John Henderson with HH Law. Today we're talking about a very important subject for all of us. Do I need a will? So, do you need a will? I'm going to go ahead and tell you, yes, you need a will. All of us are going to die. All of us have things that we want to distribute to other people when we do die. So we're going to talk about the basic concept of a will today, and we're going to try to outline for you why you need a will. A will is basically a legal document that is trying to communicate to the world after you die where you want your assets to go, who you want them to go to. If you don't have a will, then there is a statute in place. You will have been deemed to have died intestate, and a statute in your state will kick in and dictate where your belongings will go. So having a will is the only way that you can prevent the government from determining what to do with all of your lifelong hard work and all of your assets. Part of what we have to determine when we're thinking about a will and what would go in a will is what is a probate asset and a non-probate asset. When I say probate, I'm talking about this is the process after you die of the court managing and making sure that all of your assets are taken care of and distributed to the appropriate people. Okay. So when we're thinking about that, there are some assets that you leave behind that already pass. Those are non-probate assets. And then there are some assets that haven't passed yet that they will dictate either according to the statute if you died intestate, or they will pass according to your will, the terms of your will. So when we're looking at non-probate assets, we're thinking about property owned with right of survivorship, for example. My wife and I own our home together with right of survivorship. So when I die, she will inherit that right out. That doesn't go through the probate court. So anything owned with right of survivorship is out. So is any sort of retirement plan. If it's a qualified retirement plan, that is out and automatically passes. Life insurance is out and automatically passes. Bank accounts that are owned by two parties. My wife and I are both on a bank account. That will pass just to her right out without having to go through probate. So all of those things will go and pass without me dictating what to do with them. However, there are lots and lots of items on the other side of things that they are deemed probate assets. A bank account, just a general bank account in my name, for example. Possibly my interest in a business. If I own property of any sort, real estate, furniture, guns, artwork, anything like that is going to be part of my estate and probate assets as well. So there are lots and lots of instances, stocks, bonds. We could go on and sit here most of the rest of the day, but you kind of get the point that most things are in that probate world unless they're specifically excluded. So there's not an exhaustive list, I don't think, out there in the world, but what happens to my clothes, for example, this jacket? It would pass as part of my estate because it is not one of those items that is deemed as probate item. So all of those things have to go somewhere according to some terms. So how does that work? When you pass away, if you have a will, it will assign a personal representative or an executor to help distribute these items. You'll open up probate and go through that entire process. But the will itself is an instrument that is going to tell the personal representative what he or she needs to do with these items. Part of a will is going to say your general estate will be divided up this way. But there's a lot of nuances to it. I have 4 children, for example. If my wife has already predeceased me, and I say in my will that I want everything to go 4 ways equally to those 4 children, to my 4 children. But you can have a codicil or some other document, a memo saying, I would like these items to go to my oldest child, and this item to go to my second, and this couple items to my third, and then this one to go to my fourth. I can do that as well and make it very specific for those people. You usually do that in the instance of personal property, furniture, artwork, guns, different items, pictures, different items that I thought were very important and might match up with that specific child, for example. The rest of your will is probably going to say, or a lot of times it's going to say, a percentage that you want to go to somebody, or if I want something to go to this specific charity or to somebody else, one of my nieces or nephews, something like that. You can dictate exactly how you want your estate to go. And so in the context of your overall estate plan, a will is a very vital thing for you to have in place. It allows you to pass your items the way that you want to, your life's work, everything that you have worked for over your lifetime, to the people you want to. Otherwise, the government is going to step in and do that on your behalf. There's also an issue of whether or not you would set up trust, healthcare power of attorneys, life insurance, lots of other little areas here trying to move things, retitle and redeed things, for example, that would play into this as well. So there's a lot of little wrinkles and elements in terms of your overall estate plan. But a will is probably the cornerstone of any estate plan to make sure that the world knows who gets your stuff when you die. And keep in mind, the rules of wills and estate planning and probate really are case specific, state specific most of the time. Now, I create a will in the state of South Carolina. The state of New York or the state of Illinois or Texas, all those other states are going to recognize my will as legitimate and good. The Constitution has a clause in it called full faith and credit. So they are going to recognize in those other states documents and contracts that are created here in the state of South Carolina. But it's always best to have state-specific wills, estate planning documents. Everything throughout the law is really state specific. So it's important to look at the rules in your local state. So if you want a will, I suggest that you contact a lawyer in your state. If you're in the state of South Carolina, contact us. We're happy to sit down and talk to you about your estate plan and try to help you get on the right track. I'm John Henderson, and this is HH Law.